She's looked me in the eye and been adamant she's done nothing wrong. We've had discussions regarding the dynamics of the house, the conversations she had with him. And she's been consistent, she's been clear, she's been unwavering.
We're going one-on-one with the attorney standing by the side of a woman who's accused of holding her stepson captive for 20 years inside their Waterbury, Connecticut home. What he says about whether she would take the stand in her own defense. What do you have to say for yourself?
You know what you did.
Kimberly Sullivan's 32-year-old stepson weighed 68 pounds when he was rescued from a fire inside their house in February. The chief of police said this case is the worst treatment of humanity he has witnessed in more than 3 decades in law enforcement. You'll hear, though, why Sullivan's attorney says his client is innocent and that there is more to this story, including medical records and witnesses who at trial could back Kimberly Sullivan up. We're on the case presented by Law&Crime. I'm Chris Stewart. I just spoke with the attorney for Kimberly Sullivan. He has been an outspoken supporter of a woman who is facing allegations that even a judge said in court, quote, are the most troubling I've seen during my tenure as a judge.
Come on, come down, come down.
Come on down.
Who else is in the house? Who else is in here?
My stepson is in here.
How many other people?
Help him out.
Listen,
That's it. I have 2 cats.
Everybody's out?
Yes.
But your stepson's still inside?
Yeah, he's right here.
Okay,
yes.
come out. Come down the road. Come on, come on. It's not safe to stay here. Come on. It's not safe to stay here.
All right, my dog is shaking.
I know.
So now you might know this story. We've talked about it a lot here on Law&Crime. Kimberly Sullivan fled her home as it was on fire on February 16th. But inside the house, firefighters found her 31-year-old stepson who weighed only 68 pounds. Once in the hospital, that man, who now wants to go by the name S, told police what he said happened inside this home. He said that Sullivan, his stepmom, held him captive since he was 11 years old when she pulled him out of public school. In the affidavit, police say that Sullivan briefly spoke with them outside the home. She told police that S, again, that's the name he wants to go by, quote, had a lot of problems. She also said that she had taken S to see a psychiatrist a few times because he had mentioned hurting himself in the past. When detectives tried to talk to Sullivan again later on in the investigation, she refused to meet with them and said she had spoken to an attorney and she would not be speaking with police. Her stepson said that he was kept in a room in the home for 22 to sometimes 24 hours a day, and he was only let out to do chores. He told police that some of his earliest memories were sneaking out of his room to get food and a drink. When he was caught doing that, he would have to drink from a toilet, he says, because he was only getting 2 cups of water a day. He says he set the fire that brought the authorities to his house because he wanted his freedom. He lit printer paper on fire using a lighter and hand sanitizer, which he read was flammable. Now, the lighter he got, he says, from his biological father a year prior, before he died in January 2024. As his biological mom said that she gave her son up for adoption when he was very young, hoping that he would have a better life with his biological father, who was married to Sullivan. We know that DCF was called twice to Sullivan's home in 2005. That was after S was pulled out of public school. The school's principal says that the boy would drink out of toilets, that he would steal other kids' food at school, and he also said that S told him that Sullivan, his stepmom, wouldn't give him food when her 2 daughters who lived in the house would get food like pizza. Her daughters have not been charged in connection to this case. DCF found no evidence of wrongdoing. Kimberly Sullivan is charged with assault, kidnapping, and unlawful restraint. She pleaded not guilty, and her attorney has said that she was shocked to learn that she was being accused in this crime and to learn what was being alleged against her. He has also repeatedly said that she's innocent. That attorney is Ionus Colloidus. I spoke with him a short time ago. I want to take a moment and thank Morgan & Morgan for sponsoring today's Law&Crime YouTube takeover. Morgan & Morgan is a law firm with more than 1,000 attorneys and a history of winning. Just in the past few months, they were able to secure a $9.3 million verdict. That was for a car crash in Florida, $5.6 million for a car accident in Atlanta, and $1.8 million in Kentucky. And in that case, the insurance company was just going to offer $5,000. So even if you don't think your case is worth millions of dollars, why not fight for what you deserve? Morgan & Morgan makes it so easy to file a claim. You can do it from your phone with just 8 easy clicks. So head over to www.forthepeople.com/takeover. You can also scan the QR code on your screen or use the link in the description box of this video. Sullivan's case is next expected in court on May 27th. As for her stepson, he recently released a statement saying that he is getting stronger as he recovers and, quote, "I am a survivor of more than 20 years of captivity and domestic abuse. I was held prisoner in my home from the time I was taken out of the 4th grade at age 11 until 2 months ago at the age of 31 when I purposely set a fire that helped set me free." A GoFundMe has raised more than $300,000 for him at the time of this recording. Joining us now is Kimberly Sullivan's defense attorney, Ionus Colloidus. Thank you, sir, for taking the time to be with us today. One question I do have out of the gate. I know you filed a motion earlier this week for your client to get her cell phone back. What's the status of that?
We anticipate that that will be granted. It was going to be done on the papers. I'm just waiting for the paperwork back, and she should get that back either this week or early next week.
And as we look at this case, I know as we've been watching your statements outside of court and your statements in court that you've been frustrated with some of the media coverage. I know that you have said that your client is innocent, that she is shocked of these allegations, and that there's a lot more to this story than what we've been hearing from the police. But why should people not trust the words of your client's stepson?
Well, so right now, those are just one person's allegations. And what I can tell you, having done this more than 20 years now, is a lot of times these allegations fall apart. There are problems with the story. And unfortunately, I can't get into all those details now because a lot of this is ultimately going to come out at trial when certain people take the stand through cross-examination, through the introduction of our testimony from our witnesses and our experts that we anticipate. What I can tell you is I've had extensive conversations with my client, and she disputes the claims. She says it didn't happen. And, so I understand the whole world wants to believe the claims that are being made by her accuser, but I think those claims need to be examined critically. It's not enough to say, I was locked in a room. Look, there's a lock on the outside of the door, and then nothing more. And that's what we're really going to do throughout this process and at the time of trial.
And I know that you've said the fact that he was 68 pounds when firefighters took him out of the home, that doesn't prove that there was abuse inside of the home. But what was your client's reaction when she heard that that's what he weighed?
I can't get into too much about what she said. She didn't know his exact weight. He was always thin. He's always been very thin. And some of the records that we've started receiving are painting the records from the Department of Children and Families from an investigation that occurred when he was 4 years old, an investigation that occurred when he was 8 years old, an investigation that occurred when he was 12 years old. His weight, height and weight are cited throughout those reports. He was underweight throughout that period of time. However, he was cleared by his pediatrician. That is contained in the records. The pediatrician cleared the family with respect to any weight issues, and so did the Department of Children and Families. Multiple times.
Do you
This
have the
was addressed.
pediatrician's name?
I do.
And are they prepared to testify on your client's behalf at trial? If this were to
At
go
this
that
point,
far?
At this point, I haven't spoken to that pediatrician. I honestly don't even know if he's alive. This is something that was recently within the last, I think I've had these records maybe a week. So, I mean, there's still stuff that's coming in. And that's why I'm urging people not to rush to judgment, because the more discovery that we get in, the more problems we see with the state's case, the more areas that we are going to be able to investigate and uncover holes. So that's why I'm urging people not to rush to judgment, because the more information I get, the stronger the defense gets.
I know her late husband passed in January of 2024. When you talk to your client, what does she say? How does she characterize what her marriage was like to Craig Sullivan?
Unfortunately, I can't get into too many details with that, but what I can tell you when it comes to the decisions that were made for his son, Craig Sullivan is the one that had the ultimate say. He is the one that dictated whether this child would go to school, whether he would go to doctors, whether they'd cooperate with DCF. These were not decisions she made.
How can
It
you
was,
prove that
yes.
that was the dynamic that they had in the home?
Believe that's going to come out through testimony of potentially several witnesses. Not, my client may ultimately testify at trial. She may not. She would obviously be able to testify about that. There are others that I believe will be able to testify as to the dynamic as well.
His former, the stepson S, which is the name he wants to go by, his former principal gave an interview to NBC Connecticut, and he talked about multiple instances where, in his view, S was drinking out of the toilet. He would steal other kids' food. He would talk about his mom buying pizza for her two adult daughters, his stepmom, your client, and he wouldn't be allowed to eat that. And then he, in multiple parts of that interview, talked about having conversations with your client, but not with Craig Sullivan, the father, which would suggest to someone looking at that she was an active parent in her stepson's life.
Yeah, so I mean, I think given their work hours, she was probably the one that was more available, probably the one going to the school, probably being the front person, but she was not the one making the decisions. And some of what's been relayed through the principal, I believe raises more questions. And it doesn't necessarily point to abuse, it might point to other problems. You have a child that's drinking out of a urinal rather than a water fountain. He wasn't being held captive at school. There was no restraints on him at school. There was no years of conditioning when he was 4 years old. So drinking out of toilets and urinals rather than water fountains, when there's no obvious reason not to use the water fountain, I think raises more questions. And the questions, there should be questions asked about that, not just the conclusion that Kimberly Sullivan did something wrong. I think it's clear there was a problem long before my client was active or involved in this child's life.
When did you talked about a pediatrician having seen the boy's weight when he was a boy? When was that? How old was he when he last saw a doctor?
I can't tell you as far as last saw. I can tell you that the records I saw with respect to DCF, where DCF did communicate with the doctor and the doctor uh, addressed any concerns regarding weight. I know I've seen records for 4 years old, 8 years old, and I believe 12 years old.
Did Kimberly Sullivan take him to a doctor he was a minor till he was 18 years old. Did she take him to a doctor at any point from when he was taken out of school until he was legally an adult?
I don't know specifically during that time whether there was trips or there weren't trips. But again, during that time, those were decisions that were not being made by her.
Looking at her, I think of the last court appearance that Kimberly Sullivan had, and the state said that their case became stronger because several witnesses have come forward. And there was one witness they talked about, they said was a friend of Kimberly Sullivan for 21 years. She was never allowed in the house, and Kimberly Sullivan never talked about her stepson. What does your client say about that?
So there's going to be a lot of people that are going to come out of the word work. And there's a lot of people that are going to rush to say something bad about her to get their time in the spotlight. Unfortunately, we do have to deal with those people and the claims that they are making. But interesting, what that person is not saying is that they ever saw any restraint, that they ever saw anyone held in captivity. There are plenty of families that have very different dynamics. There are families where siblings don't talk for decades, don't acknowledge other family members. There's good relationships and there's bad relationships. The full dynamic of this relationship, I think, will come out at the time of trial. But my client has told me that they generally had a good relationship. They interacted on a daily basis. They were in the kitchen together every morning. There was no hostility. When I say my client was blown away and is blown away, that's not an understatement. That's not theatrics. That is the honest truth.
I know that he, as an adult, and you've said this, he can take care of himself, in your opinion, though he was at 68 pounds and medical experts told police that he had some very serious health conditions when he was taken to the hospital on the night he was taken out of the house when there was the fire. Why did Kimberly Sullivan not reach out to authorities, or did she reach out to authorities over the years when his weight was getting so bad. And it's not just his weight when he steps on the scale and the number, but the fact that he was having serious health conditions when you are so underweight.
The evidence that we believe will come out at trial will be that she did encourage him. She could not force him, though. So you can't force someone to get help if they don't want to. She did nothing to restrain him or prevent him. And from a legal standpoint, that's where her obligation ends. She's not obligated under the law to force someone to take better care of themselves. She did not commit a crime in this case.
Were people allowed inside the home?
I believe there will be testimony that there were people inside the home at times. I have no reason to believe that anyone was prevented.
Does Kimberly Sullivan have any pictures of her and her stepson over the years from the time that he was taken out of school to 32 years old, 33 years old as he is now?
So we are going through some of the pictures that were found in the home. That's something that'll probably come out at the time of trial as well.
Have police ever been called to the house? I know there was the 2005 after DCF was alerted, but had police ever been inside the home from after 2005 until that night in February?
I believe so. And I don't have the records in front of me, but I believe at least one local newspaper reported 14 instances of police contact over the years. I don't know exactly how many of them were actual officers coming to the home, but I do believe there were multiple times where my client herself called the police to the home for something that either happened inside or outside or near the home. So there were multiple instances of her essentially inviting the police to the home during this time period. And that's something that I think will come out of trial as well.
Are you aware whether S had contact with police officers when they came to the home in those instances?
Now, I believe there was at least one time where her accuser did have contact, I believe, directly with the police. I don't have the exact date on me.
For you moving forward, you talk about Kimberly Sullivan. Is she prepared to testify at court? Is that your advice to her?
Well, it's still premature to make that decision. And I would remind people that she actually has a right not to testify. And it is entirely possible that she may not testify. This case really depends on the strength of the testimony of her accuser. And if her accuser cannot testify credibly, this case ends. She may never have to take the stand. We may never get to that point. And that's what we anticipate will happen. However, if she chooses to testify, it's ultimately going to be her decision. She does want her voice to be heard, so it's entirely possible that she will. But that is something that's really a decision that ultimately is sometimes made at the time or right in the middle of the trial. Obviously, you prepare for it, but a lot's going to depend on the state's case and how the evidence goes.
I know you've been frustrated with the pictures that were released by Waterbury police showing the inside of the home that I know we noted was after there was smoke damage from the fire inside. But how do you explain the locks that were on the outside of the door? And I know you said that they were there before she moved into the house. It looks like an older home. How can you prove that those locks were there prior to Kimberly Sullivan living in that house on Blake Street?
The way a lot is going to be proven in this case through the testimony of witnesses. It may be through her testimony. It may be through the testimony of other witnesses. I think the bigger issue is how is the state going to prove that those locks were actually used? How is the state going to prove that those locks were engaged during a time where my client is charged and where this individual was unable to get out? I've reviewed the discovery and I have yet to see that.
When you look at pictures of the home, and a lot of the cupboards in the kitchen were closed, but I saw some cans that were there, and I believe you've said that there was food in the house. Is that correct? That there was food in the kitchen? I know there was like a K-cup machine. And I just wonder, knowing that he was as light as he was, police had said, the medical staff at St. Mary's in Waterbury said that he was severely malnourished, he was near starvation. What stopped someone who's 68 pounds and in that condition from going downstairs and getting something to eat?
We have no idea. That's a good question. And that's something that he's going to have to answer. My client's made clear he was not locked in his room. He was not prevented from going in the kitchen. He was not prevented from going in that refrigerator or in those cupboards. And I don't have all the pictures in front of me, but there's pictures of that fridge full of food. And there's no locks on the fridge. And my client has made clear that he had access to all of that.
I know she has two adult daughters who lived in the home. S says that they were aware of what he alleges was happening inside of the house. Are they cooperating with your defense as you build it?
So, out of respect for their privacy, because their lives have been turned upside down, I really don't want to get into too much with respect to where they are. I believe they lived relatively normal lives prior to this, and their lives have been turned upside down as well. So, out of respect for their privacy, I don't intend to get into anything about them.
What type of access are you expecting to get to the alleged victim in this case?
No, that waits to be seen. Usually, a defense does not get any access. In Connecticut, we don't have the right to take depositions in criminal cases like you don't get to in most states. We do anticipate getting records, medical records, any other records that might be out there, provided we have an appropriate legal basis to pursue them. As far as access to the individual himself, by way of, if you're suggesting like a medical test or an expert to examine, that's that's something we are going to consider. That's something that, if appropriate, we will seek. It's still a little early right now. I think the first step is actually taking a look at some of the medical records and seeing what the claims are, the conditions were at the time that he was initially taken to the hospital.
I know I have the response here to S's statement that he made through an organization in the last couple of weeks talking. It doesn't specifically mention your client, but you start with a statement I think a lot of people would agree with. The worst thing that can happen to a human being in this life is to be victim of a heinous crime. Nearly its equivalent is the horror of being falsely accused. But then you say the accuser's public narrative put forth by his handlers. What did you mean by that?
Well, clearly there's people that have surrounded him. Clearly there's people that have agendas. And I think that was evident in the statement.
I know you've been worried about, because of the news coverage, whether your client can get a fair trial. How likely is it you try to move this case out of Waterbury?
So I think that's what everyone anticipates, and that's kind of the gut reaction to this. And I think that may be appropriate, but it's still premature. We're still gathering information. We're still obtaining the discovery. We're still going through it. My hope is that the public narrative and the public perception will change a bit. I think as time goes on, I hope people take a step back and look at everything objectively and recognize that it is the state's heavy burden to bring these, what are now allegations, the long road down to proven facts. Because right now they're just allegations by an accuser. They need to be tried in court, tested in court, confronted and cross-examined, and then a jury has to decide whether the story is credible. So there's a long road to go before this ends, and we can't just automatically accept the allegations that have been put forth.
And just lastly, as we kind of wrap up here, I know that you're appealing the bond conditions that were added to Kimberly Sullivan. She's on a GPS tracker right now. That's something you're appealing. I just want to start with her being given $300,000 bond. Many people have said that was a low amount, that it should have been higher. Why do you feel that was the proper amount for Kimberly Sullivan, based on allegations that even the judge in one of the hearings, I have his quote, here, he said, "The allegations are arguably the most troubling that I've seen during my tenure as a judge and show really unthinkable amount of lack of empathy." That was the judge that put her on a GPS tracker. But let's just start with the $300,000 bond. Why was that, in your opinion, an appropriate amount?
It was absolutely an appropriate amount because when you evaluate the factors that the court must consider, one is there any prior criminal record? There was none. Length of residence or ties to the community, born and raised, employment history. She's always worked. family in the area. All those factors weighed heavily in her favor. One of the other factors the court considers is the strength of the state's case and the nature of the allegations themselves shouldn't drive that, but the actual strength of the state's case. If this individual was actually found locked in a room, perhaps the bond would have been higher. But what we have here are allegations and someone in a poor physical condition. We don't have any evidence connecting the allegations to that. You have these locks, but not one was engaged. There's been no evidence presented that they were ever used or when they were used or how they were used. There was no allegations of any physical violence. Over 20 years, one slap was alleged so far, what I found in the discovery. That is the extent of it. And I think the courts need to evaluate that. And the courts just can't say, well, this sounds really bad, because you can have people accused of horrible things. But if the evidence isn't there to support it, and the person has no prior record, and all the other factors weigh in favor of release, then yes, I think this bond was completely appropriate. I think I probably even asked for something less.
What's the timeline you're expecting on when your appeal to a higher court for her to be taken off a GPS tracker is going to be reviewed?
It's hard to tell. She's not incarcerated, so I don't think there's as much urgency. I believe the court has some flexibility as to whether they schedule argument or when they make a decision and what actions they take. That portion of this case is being handled by Attorney Paz of Patterson Paz. They've stepped in to help with that portion. So we're going to really follow their lead with respect to that.
And just as we have you here today, and we appreciate your time, Attorney Colloidus, because I know you've been incredibly busy. What do people not? And I know you believe that there's more to the story, and there's only so much that you're telling us because you want to save it for trial. But what would you say to someone who has looked at and reads the story of S, has heard from the witnesses who say that something should have been done in 2005, but it wasn't? What's your message to them beyond just keeping an open mind, but looking at your client? Because it does seem, I know you're defending her, but it does seem like you are a true believer in Kimberly Sullivan's story.
Yes. I mean, look, she's looked me in the eye and been adamant she's done nothing wrong. We've had discussions regarding the dynamics of the house, the conversations she had with him. And she's been consistent. She's been clear. She's been unwavering. And Kimberly Sullivan, the whole world is essentially against her. And she came in our office looking for help. And I know a lot of people think that she shouldn't even have a defense. Or if she does have a defense, it should just be one where you just accept responsibility, say you're sorry. And, the fact that she's even asserting her innocence is driving people mad. She came to us for help. We're proud to defend her. And we're going to not leave any stone unturned. She's adamant she's done nothing wrong. We're going to hold the state to their burden. We're going to hold the accuser to the allegations he's making. And this is going to be for a jury to decide. There's a long road ahead of us. There's a lot more to come. We're confident in our case, and we're really looking forward to her day in court. That's what I can tell you.
Has the state, because I know they said more witnesses came forward, do you know who those new witnesses are?
Oh, the ones coming out of the woodwork?
The ones the state said were had come forward since the case first came to light.
So I have yet to see any witness list. That's still premature. The discovery is coming over, so I don't have those witnesses that were referred to at that time, but I do anticipate getting that in the next couple of weeks. I do believe they're working diligently to get us everything.
All right, Attorney Ionus Colloidus, thank you, sir, for taking the time to be with us. We appreciate it.
Perfect. Thank you, Chris.
For On the Case presented by Law&Crime, I'm Chris Stewart. We'll see you next time.